Good evening, everybody. So great to see you all. And I know I always encourage folks to turn on their camera so we can see your beautiful faces, but I don't want to make anybody feel bad if you're already in your jammies and eating your dinner. But Dina, nice to see your beautiful face, and Phyllis and Ellen. And I know I'm kind of scrolling through here, Elsa and B. My college friend Krista's here. Sarah, hey. So nice to be with you all. I'm Julie Evans. I'm the executive director of Roots and Roads, and I know most of you know what we're all about, but for those who may be coming for the first time, we focus on a few different things. One is financial assistance for low-income hospice patients, and that's something we do behind the scenes. It's not really public. We work directly with hospice social workers around southeastern Arizona. But the other thing that we do is education around end of life, including grief and other issues. And so that's what we're here for tonight. And we're so glad to have you. Next slide, please. Super grateful shout out to Elsa, Linda, Dina, B, Mark, and Marcia for your individual support of tonight's session. Your gifts really help us make these sessions free and open to anybody. And so thank you for that gift. And now I'm going to turn it over. Well, I do want to just say one more thing. So grateful to have Rachel Sass, who was a board member of ours for many years. She was our board chair. And anyhow, just super grateful that you're here tonight, Rachel. Thank you. David?
Thanks so much, Julie. And if we go on to the next slide, and in addition to all those amazing people who made contributions for tonight's session, we also have our series sponsors. These are organizations who we partner with throughout the year in order to provide and create a more compassionate and caring community here in southeastern Arizona. So we're especially thankful to Sunset Hospice, Hospice of the Valley, Casa de la Luz Hospice, Right at Home, In-Home Care and Assistance, and Pima Council on Aging. These are partners who we've worked together with for many years. And we really couldn't do this work without these partnerships in order to be able to reach folks who are most in need and be responsive to what will make a difference in their lives, bringing care and dignity at a very fragile time of life. So we're so grateful to all of these organizations. All right. And as Julie mentioned, we are very happy to have Rachel Sass with us tonight. Rachel is a Tucson native. I had that right, Rachel? Yes, Tucson native. And I remember she had said that she's a double wildcat, which I guess means that she received her bachelor degree and her law degree from the University of Arizona. Rachel is deeply rooted in this community and incredibly generous in service of Southern Arizona. As Julie said, she served on the board of directors with Roots and Roads for 6 years. Is that right? And then also with a stint as our board president again for her wisdom and guidance, and are so grateful that she can be with us tonight. I encourage each of you to take a moment and read the bio that there is before you, or if you want to refer back to it, it'll be on our website as well. Rachel, thank you for your willingness to share this important information about estate planning, and we'll just go ahead and turn things over to you now.
That's it. She left.
That's it. I
all,
must have said something rude about her. I didn't say she went to ASU.
It's a crazy Zoom night, maybe.
That's okay. Does anybody know a good joke while we wait? No jokes. Okay. Here she is. She's back.
Uh-oh. Don't know what happened. There we go again. Okay, let's try it again, y'all. All right, I think we got it on that one. Can I get a thumbs up? I want to just
Yep,
confirm I'm not the only
Yep.
one.
you
Okay.
got it.
All right.
That's great.
All right. Well, thank you so much, everyone. I'm very, very happy to be here and present tonight. This is something I'm very passionate about. I've done estate planning my entire career. So I get the fortunate experience of just talking about death and dying every single day, which is really fun. But this is just something, it's very important. I'm very passionate because it's an area of the law that is not common sense. It's still a very old, antiquated system, and it's a very black and white area of the law. And so, if one thing may not be right, it kind of throws the plan into awry. So, I just really want to, let everyone know kind of what's going on so that they can best prepare. And so, hopefully, that's what we're going to take away tonight for all of you. So, with that, here we go. So what are we going to talk about today? So I want to just introduce you to what is estate planning. I'm throwing around this concept estate planning, but what actually is it? What does it entail? We're going to go into Arizona basics and probate. Now I know the Roots and Roads education series can reach far and wide. So I apologize if you're not in Arizona. I am an Arizona licensed attorney, so I'm going to talk about Arizona. Estate planning is very state specific. Okay, I do want to mention that. So even though I'm going to cover some Arizona basics here, if you are located in another state, you do want to check in with a local estate planning attorney because, again, laws are very specific. There's overall general concepts that will transfer state to state, but the nitty gritty is going to be state specific. So you always want to check in on that. How to get in a little disclosure there. Then we're going to really deep dive into estate planning documents and what your foundational documents are going to look like. What does each one of them do? How do they all play together? And then we'll conclude tonight by planning for long-term care and how can your estate plan work with your plan for planning for end of life and care for you and your loved ones. So if that all sounds like I do have to give one legal disclosure up front, get all the boring stuff out of the way, which is that I'm not giving legal advice, even though I am a licensed attorney. We're just going to be talking about concepts. I can give you my suggestions, recommendations, but ultimately I do have to refer you back to your estate planning attorney for any legal advice and going from there. So with that boring stuff out of the way, let's get going. One important thing though, is at the bottom of your screen, as Jennifer is kind of talking about the controls, there's that little heart button. That's the most important button, guys. I love hearts. Um, in the age of post-COVID and we're giving virtual presentations, I'm going to be talking to my computer screen and pretending that all of you are smiling and laughing and loving it all. And hopefully you are. And if you're not, just go ahead and turn off your camera and you can make all the horrible faces at me if you want. But otherwise, I want to make this interactive. If you've got questions, shoot them over into the comments, jot them down. I want to get all your questions answered too. And with that, let's keep going. So let's talk about what is estate planning from the get-go. What are we going to talk about today? What an estate plan really is it's a legal method to control how your property is during your lifetime and at death. Now, a lot of people think that estate planning is only for upon your passing, and that's not true. Actually, a majority of it is for how it's going to be managed during your lifetime, and in particular, during any period of incapacity. So it's a very, very important method. And then, of course, at death, how do you want your assets to be distributed to what beneficiaries, to individuals, families, friends, charities, you name it. That's what you get to decide in your estate plan. Now, I've talked to a lot of people before and they say, well, I don't have an estate. I'm not Jeff Bezos. I'm not them. I don't have an estate. Yes, you do. If you got $1 in your wallet, in your back pocket, a penny you got stuffed in the an estate. Okay. Estate is just property. It doesn't matter how much. You could have 10 bucks, you could have 10 million, you have an estate. And so again, it's whatever your property is. We think about our personal property. And that's honestly the stuff that really causes the most fights when we talk about estate planning because there's sentimental value there. So it doesn't have to be big net worth numbers. It's just property. That's what it is. So we're planning for how we're dividing, how we're managing your property during your life and at death. So going into some Arizona basics and a little bit about probate here. So first, when we're talking about Arizona basics, I have to mention community property. Arizona is one of 9 community property states. What community property is basically a property that was acquired during the marriage and any income that was earned by a married couple. Separate property is property that was owned prior to you getting married, or if it was received by an inheritance, whether before or after marriage. Now, what community property really means is that each spouse in a marriage has a 1/2 interest in community property. So, how this really relates to estate planning is because you only can give away what you actually own and what you're entitled to. So in a community property state, each spouse has that 1/2 interest in the community property and then all their 100% interest in their separate property. And that's what you're allowed to distribute in your estate plan, that 1/2 share and all of your separate property. Now, typically you hear about community property getting brought up in divorce, right? My spouse took half of everything. And that's true. Because they own 1/2, they have a 1/2 interest. But community property has a lot more effect in the estate planning world as well. Community property is actually a really great mechanism for income tax planning. Can really provide some great benefits there as well. And there's also some different ways that you're able to title property with community property having kind of that designation here. So it's a really great thing to kind of take advantage of here in Arizona. Now, when you think about community property, I kind of want to give you some examples because you think of, okay, from the time someone was married, that's kind of your trigger point, whether there's community or separate. But of course, with the law, there's always going to be exceptions, right? And we can go down 1,000 rabbit holes from here. So when you think of community property, for example, my husband and I, we got married in 2018, got married right after I graduated law school. I was a poor little law graduate. I had a bank account and I had a car, and that was all I had. My husband's a bit older than me. He's been working a while. So he had a house in his individual name. He had his own bank accounts and he had a 401k. A lot of people kind of forget about the retirement accounts, but those are huge pieces of right there. All of that was his separate property, right? I have no share, no interest in that property. Since we've been married, though, we sold that house. We bought a bigger house. Now we have our names together on our house. So now our house is community property. We have a joint bank account. That's community property. And he still has his 401k. Now I have a 401k as well. Now my 401k, I created it during our marriage. So it is 100% community property. My husband's, he did have it before the marriage, but obviously it's grown since we've been married. So the earned interest, the earned income in that 401k, that's community property. I have a 50% share in that. So it's just little things to think about here. Community property can encompass so much more than what people originally think of. And there's also ways that you can make separate property and turn it into community property. So for example, if my parents gave me an inheritance, that's, just my money, my separate property. If they gave me $100,000, let's say, but then I popped that $100,000 into a joint bank account with my husband and I. We started paying bills with it, childcare, you name it. Well, I just kind of converted that to community property. So again, there's a lot of little intricacies here, but just so we're kind of aware when we're talking about estate plan, this is what we're able to actually manage and control and distribute upon the passing. Moving on to types of assets. We want to kind of get all these little, just the basics down first before we really get nitty gritty. So there's really 2 types of assets that I like to think about. One is going to be estate assets. Now, estate assets, again, we talk about estate just being property. These are going to be assets, and these are assets that are going to be subject to probate, which we're going to get into right after this. Now, these assets are titled in your individual name, and they have no beneficiary designation or no rights of survivorship. And again, if you have those kind of assets, they're going to pass via probate if the total value of it is over $200,000 of personal property or $300,000 of real estate. I want to break that down a little bit. And these numbers actually just got changed last year by our Arizona legislature. They were way, way outdated beforehand. So we're very happy they did that, given inflation and everything these days. $200,000 of personal property. What that consists of, that's bank accounts. That could be an investment account. That could be your cars. That could be all of your personal belongings in your house, your jewelry, if you have artwork, whatever it may be. So when you think of all that, your car, the average car these days is like $50,000, whatever's in your bank account, personal property, if you have an investment account, you could get over that $200,000 threshold pretty easily, depending on what type of assets you own, just depending on if we forget about something, whatever it may be. Now, the $300,000 of real estate, that seems pretty low, but I want to back it up a little bit because the Arizona legislature gave us a little bit of wiggle room there. Now, the $300,000, how that's valued is it's the property assessed value. Now, we all remember every year you get your property assessed value. Your house, let's just say, is worth $600,000. They assess it at $500,000. It's usually right. It's a lot less than like what Zillow says your house is and what you could actually sell it for on the market. Okay, so it's your assessed value, and then you reduce that by any outstanding liens or mortgages. So again, if you had a $600,000 home, your assessed value was $500,000, and you still have $200,000 outstanding on your mortgage. There you go. This is how we're going to get to that $300,000 right there, right? So it's going to you got a little bit of playroom there. But again, these are going to be assets titled in your individual name. We got no one else on there. So if that house was jointly titled between spouses, it's not going to count because we got another person on that deed. If you have a bank account and your bank account is only in your individual name, so I've got a checking account at Northern Trust, just Rachel Sass, no beneficiary designation, nothing. That would be an estate asset. That would be an asset that would be subject to pass via the probate process if it got over that threshold. So those are what estate assets are, and I'll give you a couple more examples as we go through. Trust assets is kind of the other bucket that I like to think about. Now, trust assets are assets that are going to be titled in the name of your revocable trust, and they're going to pass according to your trust agreement. Now, with a revocable trust, we'll get into this when we get into the documents, but a revocable trust is basically you and the trust are one and the same person. It's a disregarded entity. It's just we're adding a title to your name, as I like to say it. So my husband and I have the Sass Family Revocable Trust. Him and I are trustees of the trust. We could do anything we want. Instead of just Rachel and Stephen, now it's Rachel and Stephen as trustees of the Sass Family Trust. So the reason why that allows you to avoid probate and it doesn't fall into this other bucket of estate assets is because technically you don't own it in your individual name. The trustee owns it and manages it in your trust. So it passes according to your trust agreement. So it's a different bucket. We don't have to worry about it having to pass in the estate and the probate process. So now we got that distinction out of the way. Let's talk about probate. And I'm sure when I say probate, either you might not know what probate is, or usually the most common is something negative. Anytime I say probate, it's just I get frowned all the time. Everyone's always got a story of they either went through or someone they know that went through probate and it was a horrible experience for them. And that's unfortunate. Probate is not the worst thing in the world, but it's an inconvenience. As I like to say, it's just annoying to have to go through. What probate is it's the legal process whereby it's a court process whereby a judge is going to determine if there is a legitimate and a valid last will and testament of our decedent, the person who has passed away. And if there's not, who their heirs are, when we're going to look at the intestacy statute. And then they're going to appoint a personal representative, or also known as an executor. And that's the person who's going to be in charge of collecting all the property, all that estate property. They're going to pay any creditors, and then they're going to distribute out the property either by a will, if there was one, or to the heirs according to our intestacy statute. That's really what probate is. Doesn't sound that bad when I say it like that, right? Now let me give you the flip side, which is probate is a minimum 6-month court process whereby all of your assets, who your beneficiaries are, all becomes a public document. When I say it like that, people, that's when they have the frowns and they don't like that idea. And so probate really, it's a 6-month process because we have to give time for any creditors to potentially make a claim. Whoever is entitled to basically files in court saying either I do have a will and it's their last will, or oh, they passed away without a will. They or someone else gets appointed, and then that person is in charge. They have to gather all the assets. They have to tell the court what all the assets are. So they're going to write a big list. They'll say, oh, they got, Wells Fargo checking, they have a savings account at Hughes Federal Credit Union, they had their house, they had a car, they had a golf cart, and they'll go down and they'll list everything on there. And then they'll say who's entitled to everything, whether if there was a will, what did the will say? And so, for example, if someone, gave only 70% to their daughter and 30% to their son, because their son wasn't very nice to them, the son's going to know. The son's going to find out because that's a public document. Or if there's heirs, all the heirs are going to see. And so that's where people start, again, not liking the whole probate process. Probate, though, at the end of the day, even though it's a public process, even though it takes a minimum 6 months, in Arizona, as compared to other states, it's not as bad. In Arizona, the court filing fees, the last time I checked, were about $1,500 in total filing fees. You likely will need an attorney, and so there's going to be legal fees in addition to that, which can be paid out of the estate. But again, compared to other states like California, for example, the court fees are based on the size of the estate. So in California, let's just say you had $1 million estate, just a basic house in California is like $1 million now. So you had just $1 million, all you had was a house. And let's say the court fees were 5% of the estate. I'm not entirely sure, but it's somewhere around there. Your court fees are $50,000. And that's, again, not including attorney fees. So again, Arizona, in comparison to other states, really isn't that bad of a probate process. Typically, in my experience, I've seen the probate process last about, on average, a year to a year and a half to get through, just depending on how complex it is and what the assets are. But again, if this is a goal of someone's to avoid probate, then we want to work on an estate plan. We want to work on some of these techniques to avoid this process if this is something that doesn't sound great to you and you want to avoid. So let me give you some examples real quick of what might trigger probate. So let's say in example 1, we got Bonnie, and Bonnie died and she owned a deferred annuity. And the beneficiary in her annuity was her husband, Clyde. Clyde survived her. Well, the annuity is going to be non-probate property because she had that beneficiary on there. Woohoo! So we don't have to worry. Clyde doesn't have to go to probate. But if the annuity named Bonnie's estate as a designated beneficiary, and I've seen that before, or if, shoot, Bonnie forgot to fill out that darn form when she signed up for this thing, then the annuity is going to be considered probate property, and Clyde may have to petition the court for probate. Now, example 2, we got Sonny and Cher in this one. So Sonny and Cher, they own their home together as community property with rights of survivorship. This is a big thing, and I hope everyone takes away this today. Go look at your deed. Go look at the deed of your house, and how is it titled? So many times when you're buying a home, it's just so exciting, and you're working with title companies and your real estate agent and all these people and the lending company, and they just kind of do their own thing, I feel like, when it comes to the deed. My husband and I bought our last home, I had to have them correct our deed 3 times because they didn't get it the way I wanted it. So go check your deed as a takeaway from today. So they had it as rights of survivorship. That's a good thing because that means it's non-probate property. Sonny survived Cher. So he's going to own 100% of the house now. Don't have to worry about it going through probate. Last example, we have Jack. He has a checking account at Northern Trust in his individual name, Jack Dawson. Sadly, Jack was in a tragic boating accident, and his spouse, Rose, is trying to collect the account. So, but the account, again, wasn't in Rose's name. It's kind of a new relationship with those two. Sadly, Rose is going to have to probate the court, and it's going to be considered probate property. So just some examples there. You could see the different kind of, ways things are titled. That's really going to determine what bucket that's going to be falling into. Now, we talked about if you have a will, right? That's great. If you have a will, you're going to be able to say who all your beneficiaries are. Even if you got to go through probate, well, you have your beneficiaries there. Shoot, if you don't have a will, well, don't worry. The Arizona legislature, they got you covered. They wrote one for you, and that's called the Arizona intestacy statute. I actually was in a presentation last week, and the presenter, his little thing was that, well, technically, depending on the value of the estate, Uncle Sam could have a say too with federal estate taxes. So don't worry, Uncle Sam's a part of your estate plan too. So if you don't want Uncle Sam in the Arizona legislature writing your estate plan for you, we're going to keep talking and we're going to look at some documents. But if you're okay with those people getting in your estate plan, we'll go through it. So if you die without a will in Arizona, we're going through intestacy. And if you've seen some, movies out there, this is when, you get the phone call out of the blue and your great uncle died and now you're a billionaire. Oh my gosh, that's the dream, right? That's all because of intestacy. So they kind of go down through the line here and figure out who is the heir that's entitled to property. So it all depends on who's surviving you. In Arizona, if you have a surviving spouse and you have children and they're a common of the marriage, so for example, my husband and I have 3 young kids, all of them are from our marriage, then all my community property, my 1/2, and all my separate property is going to my husband. He just gets it all. Now, if I have a surviving spouse, and let's say my kids are from a prior marriage, we've got so many blended families these days, only half of my separate property is going to my husband, and the rest is going to my kids. So that means my half of the community share and half of my separate share is going to kids. So it's kind of, we got to split things here. If we don't have a surviving spouse, but we have kids, we have descendants, then we're giving everything to the kids. We're going to give it all to my descendants. Now, what if we don't have a spouse, we don't have children? Well, then, or any other descendants, grandchildren, any lying down. Then we start going up the line. We're going to go look at parents. Do we have any parents? No. Okay, if we don't have parents, we're going to go to their descendants. That would be your siblings. Okay, do you have any siblings? No. Okay, then we'll go down the line again. That would be then your nieces and your nephews. Then we're going down from there. Then we go to grandparents. So that's how you kind of figure out where the heirs are. Again, this is if you don't have a will and we need to just determine who is entitled to the property. That's how they go down the line. Okay, so I'm assuming all of you are like, no, I don't like that. I don't want Uncle Sam. I don't want the Arizona legislator. I'm going to do my own thing. So we're going to get to estate planning documents now, and we're going to do a deep dive into what documents, in my opinion, are the most foundational documents. And I want to start and preface this by saying, again, I've worked with clients who've had $100,000 estate. I've had clients who've had $100 million estate. It all starts with these documents. It does not matter. There's nothing different. These are the foundational documents for everyone. Depending on the value of your estate, the complexity, what type of assets you own, if you've got a business, if you own property in other states, if you got a second home, if you got maybe something down in Mexico, whatever it may be, then you can add on to it, right? Then you could tweak it. But these are the foundational documents, in my opinion, every single person should have. We're going to start with powers of attorney. These are really important documents. We saw this during COVID be very, very important, right? Where we've got a durable financial power of attorney, could also be called a general durable power of attorney. Every lawyer makes it a little bit different title. You've got a healthcare power of attorney, in my opinion, the most important document of all. And then you have a living will. Starting with your financial power of attorney, what this document does is it names an agent who is going to manage your property for you, any property that's in your individual name, okay? So non-trust property, individual name property. If you are incapacitated, if you're unable to manage your affairs or speak for yourself, that's what your agent is going to do. So that bank account I said that I had in just my individual name, if I got into a coma tomorrow, my agent's going to be able to step in, access that account, make sure my bills are paid, things are like that. Now, your healthcare power of attorney, again, most important document in my opinion, this is naming an agent to make medical decisions and end-of-life decisions for you if you are unable to communicate those decisions for yourself. So this is the person, a lot of healthcare powers of attorney, they include mental health powers. So this is a person who might be able to admit you into an inpatient psychiatric care. Very important if you want that or if you don't want that. This is the person who's going to decide whether or not to pull the plug, given kind of what circumstances you may be in. So a very, very important person to name here. Lastly, you have a living will. Some attorneys have this as a separate document. Some attorneys combine it with the healthcare power of attorney. This is the document that provides the instructions so that your agent on your healthcare power of attorney doesn't have to guess. They know what you want. They know what your wishes are. If you don't want to be resuscitated, if you have a DNR, you're going to put it in your living will. So your agent knows you don't want to be resuscitated. If you don't want to be kept on artificially administered fluids, you're going to put that in your living will. If you have a terminal illness, you're going to put that in there that you just want maybe comfort care, but you don't want to be kept alive artificially. Very, very important documents. Your living will is also going to talk about final arrangements. Do you want to be an organ donor? If so, to what extent? For science, for individuals, what type of organs? They're going to put in there if you want to be cremated, if you want to be buried, and you can be as specific as you want, especially when it comes to cremation and spreading of ashes. I've had clients who have literally given me longitude and latitude coordinates on where the ashes need to be spread. So this is for you, right? This is what you want, and this is what your agent is supposed to fulfill for you. So get very specific in these documents. Now let's talk about a last will and testament. Hopefully I didn't scare you off by talking about probate and wills, but wills are still important documents. What a will does do, let's talk about that. So a last will and testament, it distributes estate assets again through the probate process if they're hitting over those threshold numbers at 200 and 300,000. They're going to name a personal representative or that executor. That's the person who's in charge of gathering all those assets and distributing them out to whoever's entitled to them. Here's a key one. It names a guardian for any minor or incapacitated children. I have 3 children under 4 years old. It is very important for me to have a guardian named in my will in case something happens to my husband and I don't want family fighting over, which grandparent's going to take the kids. We know exactly who we want to take our kids. What a will does not do, it doesn't avoid probate. That I feel like is the biggest myth of estate planning. Everyone thinks, oh, I got a will, I'm good. Maybe not, depending on what your goals are. And it doesn't keep information private. Like I said, if you have to probate that will, if you have to submit it to the court, it becomes a public document. Another thing I want to add, a will doesn't guarantee that family's not going to fight. Sadly, there's nothing in the world that can guarantee to stop family from fighting. Family's going to fight, a family's going to fight. You can have the best estate plan in the world, and you could just have someone who's wanting to fight. So just keep that in mind. You could try and put as many kind of foolproof kind of guards in place, but there's no guarantee. Now, I want to talk about a pour-over will. This is very similar. It is a last will and testament technically, but it's actually what we're colloquially called a pour-over will, because what it does is it works in conjunction with a revocable trust, which we're going to talk about next. What a pour-over will does, in your typical last will and testament, I'm going to say, I, Rachel Sass of sound mind and blah, blah, blah. And then I'm going to give everything to my husband, Stephen, my daughter, Adeline, blah, 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 blah. Instead, a pour-over will says, I give everything to the Sass Family Trust. That's all it says. The Sass Family Trust is the beneficiary. And then my trust agreement is private. No one sees my trust agreement. So no one knows who I'm actually disinheriting. No one knows how things are distributed out at my death. That's how it kind of works with a revocable trust. A pour-over will acts as a safety net. A goal when we have a revocable trust is to put all your assets in the trust so we avoid probate and everything falls under that beautiful umbrella of the trust. So a pour-over will just ensures that, whoops, if we forgot something, pours on over into there. So it's great, offers more privacy. It's kind of that just in case safety net. And again, with a fully funded trust, it really can avoid probate, which is great. The only downside to it is you got to work with the trust. You got to set up the trust as well and make sure it's fully funded. But we'll talk about how that is and how you can achieve it. So with the revocable trust, what this is it's just a trust that's created before death. And when you think of a trust sometimes seems like this archaic thing, or, oh, again, only Jeff Bezos has trust. No. Anyone can have a trust. Again, anyone can have a trust. Think of a trust as just a different bucket, right? Just a different bucket to hold your assets in. Right now, you've got your assets in your individual name. We're just going to put that in a different bucket, into your trust bucket. A trust has three main players. It has the settlor, that's you, that's the person who creates the trust. It has the trustee, and that's usually you during your lifetime because you're doing whatever you want with your property. And then it's got a beneficiary. And those are your three main people. The trustee technically owns the trust assets, anything that's named in the trust. This is fully revocable. You can amend it. I've had a client who amended their trust 12 different times. Literally, you can change it as much as you want. I had one time before they called us, they changed it with their kids. It was 60-40. And then when they came in to sign, like, oh, you know what? My daughter's actually being pretty good. Okay, let's do it 50-50 again. So you can change it as many times as you want. Revocable trust, when you create it, and kind of how, again, it's just this bucket. So it's not really a thing. Doesn't require an extra tax return or anything like that. You can do everything you want. We're just putting that title behind your name. So instead of Rachel Sass owning a checking account, Rachel Sass is trustee of the Sass Family Trust, owns the checking account. And that's really all it adds. The planning perks of a revocable trust, again, it provides privacy, right? It avoids probate. I'm going to skip the third one and go back to it. It has built-in tax planning. So there's a lot of income tax and estate tax planning you could build into a trust depending on the value of your estate. It distributes assets to beneficiaries, and there's so many options, that's what I truly love. I mentioned my kids are very young. I can't give my kids property. That would cause a conservatorship. Minors can't own property, right? They can't have my house. So if something were to happen to my husband and I can't just leave them, even though I want them to get everything, but I could leave them all of our assets in trust. And so someone else would manage the trust for them. They would manage the assets, grow it for them. And let's say when my kids are 25, they can become a co-trustee of their trust. And then maybe when they're 30, 35, they could be their own trustee and they can manage it themselves. So there's so many more options, and you can put in so much more control by building in a trust with your estate plan. Now, I want to go back on here where I said a trust is, in my opinion, the best vehicle for incapacity planning. Going back to that very first slide, we talk about estate planning is about planning for your incapacity and at death. But you think today there are so many more individuals who are diagnosed with some form of Alzheimer's, dementia, just have memory problems. It's harder in life, right, to be able to manage your affairs. I will tell you, coming from an attorney, a drafting attorney, and now I work at a financial institution and I administer trusts. Financial institutions truly prefer dealing with trustees of revocable trusts than agents on powers of attorneys. And at the end of the day, if you go to a bank and you have a power of attorney and you say, I'm agent, I should be able to have access to this account so I can pay bills and take care of Rachel while she's in a coma. And they say no, because they don't like some language that's in that power of attorney. Your only other option is to go to court and get a court-ordered conservatorship. That's the only other way. Not a great option, right? You don't ever want to go to that plan B. Financial institutions, there's just more case law behind trusts. The statutes are more robust. And so financial institutions just truly and particularly title companies, just prefer dealing with trustees. Wish it could be just equal, but that's just kind of in my experience. And so, with the revocable trust, if you ever experience incapacity, there's so many levels of incapacity, right? You may not just be able to manage your finances, but you still are cognizant, you still are understanding what's going on around you. You don't want to have to be subject to a conservatorship and have to go through that process if you're understanding still kind of what's going on, but just can't manage your assets. That's what we're trying to avoid. That's really the goal of everything. So that's why I prefer trust. Now, a big thing I always get from clients is that trusts are too complex, and they don't have to be. They truly don't. You can make them really complex if you want. Your attorney would love you because of all the legal fees, but you don't have to. A simple trust structure, again, since we are in Arizona, I want to take advantage of community property. So my husband and I can have a joint trust here in Arizona. So we have our joint trust there up on the top. All of our assets are put into the trust. I'm going to take my husband out first. He's gone. The trust just continues for me. I can still do anything I want with the trust. Just helps, it's for my benefit. And then when I pass away, we're going to distribute it out to the beneficiaries. We can do it in trust. We can do outright distributions, however you want to put it in the trust agreement. That's literally, again, it's just one line. You can make it that simple. Now, you can build in complexities again if you want. A lot of the times I see, blended families. And so you always hear the story of, well, one spouse passed away and that darn cabana boy or that darn 21-year-old girlfriend came in, and then now the poor kids are disinherited. You can place controls where your kids would not get disinherited. Or again, if you just have a blended family, you each have kids from prior marriages, and you just, your spouse says they love the kids, but if you're not there, are they going to keep the kids and then the estate plan? You can place controls so that they can't change that part. So again, this is as simple as it can be, but you can add all the other options to fit what your goals are. So just to sum it up, I know we're starting to run out of time here. Documents that are effective during your lifetime. On the top here, we've got your powers of attorney that we went over. Again, only effective during your lifetime. Once you kick the bucket, they're gone. They're useless. Throw them away in the trash. Shred them. Your revocable trust is effective during your lifetime. It's also down below because it's effective upon your death. That's why this trust is like the main player here. It's a great document. Your last will and testament is only effective upon your death. Otherwise, when you're alive, doesn't mean anything. Then we've got beneficiary designations. I didn't mention that before, but that's, again, anything that you're putting on an account with your individual name. So if I had that bank account, you might hear it as a POD, a payable on death designation. And that's where I have a contract with the institution saying when I die, this asset, this account goes to this person or this charity. If you have an investment account, it's called a TOD designation, a transfer on death designation. If you have a life insurance policy, you've got a beneficiary designation on it. If you have a retirement account, you have a beneficiary designation. Technically, you could have a beneficiary deed for a house, and you could use a beneficiary deed for a house where it says upon my death, my house goes to this person. So those are also can be used, and they can be used in conjunction with all the other documents here. But again, only effective upon your passing. So planning, and quickly, real quick, I want to go right back up here because, I talked about how great a revocable trust is. And I don't want to discount Mr. Durable Power of Attorney right at the beginning because now he kind of looks like a little sad document, right? But he's really not. The durable power of attorney is still important even if you have a revocable trust. Now, I said your durable power of attorney is only effective, your agent can only act on assets that are in your individual name. So that, right, if you're trying to put everything in the trust, like I'm telling you to, then you're like, well, what's the point? Well, retirement accounts, that's the big one. And a retirement account is an individual retirement account, an IRA. You need an individual. You can't put it in a trust. So your durable power of attorney is really powerful for that retirement account, making sure you take your required distributions every year and just, pulling out the income for your support. And then if you ever leave an asset outside of your trust, sometimes you just want to leave a bank account outside in your individual name. That's totally fine. Your agent on your durable power of attorney can act on that asset as well. So this document still works together with the rest. He's not left behind completely. All right, so let's get to our last topic, planning for long-term care and how all of this relates to, supporting you during end of life. I want to briefly just go over All-Tex real quick, which is the Arizona Long-Term Care System. Full disclosure, I am not a specialized attorney in All-Tex. We're just going to go over this briefly so I can tell you how your estate plan can relate to all of this. But what the All-Tex system really is it helps pay for the cost of long-term care in a nursing home, community-based settings, can provide free health insurance through access. It can cover day programs, assisted living, memory care, some in-home care, even some skilled nursing centers. We see a lot of people relying on Altex because it's very powerful. And as you see today, end-of-life care, in-home care, nursing facilities, they are so darn expensive these days. It's ridiculous. I've had clients who spend over $300,000 a year because, wife or husband had a stroke and now they require 24-hour in-home care. And that's something if you don't budget for, it can, really, really hurt. And so Altex is a very beneficial program that we have. Qualifying for Altex can be a little bit tricky though. There's two prongs for Altex. One is limited resources, and then the other one is limited income. So for resources here, an applicant can't have more than $2,000 in resources. That's liquid assets, anything that you can convert to cash, like investment accounts, real estate, personal property. And when you have an applicant, all the resources of the applicant and the spouse are going to be considered for eligibility purposes. So it's going to be a little tricky there. Now, of course, the law is never black and white, even though I kind of said estate planning is in the beginning. Sorry about that. There's always exceptions to everything, right? And they're not going to make this easy for us here. All the exceptions here are going to be, your primary residence. If you've got an intent to return home, they're going to disregard that in terms of counting what your resources are. Burial plots, burial insurance, if you've already prepaid those, if there's no cash value to like a burial insurance, they're going to exclude all of that. If you have a vehicle, they'll exclude that. If you got two vehicles, well, you got to have like a second person, or you're using it for work, or if the individual's handicapped. Household goods, like your personal items, furniture, things like that. If it's under $2,000, they'll exclude that. Life insurance policies, if they have a face value of $1,500 or less, they'll exclude that. So there's a whole bunch of excluded resources. And so when you're trying to qualify for Altex, you really got to get into the nitty gritty, work with someone who is very aware and can help you with all of these things. Then there's limited income. Now, an applicant's gross income can't exceed about $2,900 a month for 2025. The 26 numbers are out. I apologize, it's not updated for 26. Here's the other, the good thing. If you've got both spouses applying, well, then the combined income can't be more than $5,800 a month. But unlike that resources prong that we just went over, the non-applicant spouse, if we only have one spouse who's applying, the other spouse, their income's not going to be considered. So that's a really great benefit that we're actually given here in trying to qualify for Altex. Now, when we're looking at trust and how do trusts play into Altex eligibility, all the time you think, okay, well, if it's assets in my individual name, well, I'll just put those things in a trust because I don't own them then, right? Estate trust assets. No, sorry, unfortunately, the system knows better. If you create a revocable trust because you have unlimited access, you and the trust are one and the same, Altex consider those all of your assets. So since you can do whatever you want by it. So that's not going to do it for you. Now, what are you like, okay, well, fine, Rachel, I'll do an irrevocable trust. Okay, maybe that'll do it. Well, unfortunately, they got smart and they came up with the 5-year look back period. If you put all your assets, say I'm going to create a trust for my parents, and I'll put all my assets in, and then my parents can just give me money whenever I need it. Well, shoot, they have a 5-year look back period, and I'm going to get a penalty because I did that. So if you're trying to do a plan and you're thinking of an irrevocable trust, you got to do it 5 years before you even want to get on Altex. And I wish I had the crystal ball and I would know 5 years ahead of time when I would need Altex eligibility. That's a hard thing that, you can't just pick up at the store and get that crystal ball. So hard one there. I want to talk real quickly about self-settled trust. Now, self-settled trust, what that means is you created the trust, okay? There's 3 different exceptions that they have made for self-settled trust where you're not going to get hit with that 5-year look-back penalty. So that's great. All the way on the left-hand side of the screen is the A trust. So this is what's considered just a special needs trust. You have to be under the age of 65 and you have to be disabled in order to create one of these trusts and have it qualify for this exception. You can fund it with your own assets. The only kind of kicker at the end of the day is that the remainder beneficiary of that trust has to be the state, because they want to be reimbursed for, making you all tax eligible and paying for your healthcare needs. But that's one way to get your assets kind of out, so you qualify for resources, and still be able to qualify and get the care you need. The middle one here, a B trust or a Miller trust or an income only trust, I feel like it's most commonly known as a Miller trust. This is the most common one. This is where an applicant meets the resources prong of the criteria, but they exceed that income because maybe they got a pension, or there's, they got retirement that's coming in. What you do then is the applicant puts in that excess income into the trust. They're no longer counted as available income. And then you qualify for all tax. You're able to get the care you need. And that money in the trust can be used for approved purposes. So it can go to help pay for nursing facilities, health insurance premiums, other medical expenses. Again, the only kicker at the end is that the state has to be that ultimate remainder beneficiary. They have to be reimbursed upon your passing from any remaining trust assets. But this is a really great option that we see. Lastly is a C trust, or a pooled special needs trust. Honestly, I've never seen this before, but let's put it in here for comprehensive purposes. This is where you create a special needs trust. Again, you have to be under 65. And all the assets of these trusts are going to be managed by a nonprofit organization. Again, you would be able to qualify for all tax, but the state wants to be the ultimate remainder beneficiary at the end to be reimbursed. So these are just some options here if you're going to be creating your own trust. And we're working with the two prongs of eligibility for all tax. Lastly, our third-party trust. This is if someone's creating a trust for you. They may not be considered a countable resource. If someone creates a trust for your benefit, they fund it with their assets and you have no control over it. Now, if they give you distributions from the trust, that might still be treated as income for you. So you got to be careful of that second prong of the eligibility test. But otherwise, this will not be considered resources. And this is usually special needs trust, third-party special needs trust that people create for others. And that's another great option too. So I know I just threw up so much information at you, but planning today really does give you the peace of mind tomorrow. I got this, funny comic here about thinking about death, because again, I do this every single day of my life, and it's not a fun topic for a lot of people. My parents literally just did their estate plan last week with me. They don't want to do it, right? But get the legwork done, do it up front, know that you've got the controls you wanted in place, the beneficiaries you want, and then it's peace of mind, right? You hear about stories of people who've, again, someone's passed away, a loved one's passed away. You're grieving. You don't want to have to deal with the legal system and the courts and just a big mess. So estate planning is one of the best gifts that you can give to your loved ones upon your passing. With that, I'm happy to take any questions, anything that's come in at all. I will stop sharing the screen so I can actually see y'all, and we can make this a little bit more interactive. But happy to jump in. Anyone, feel free.
Yeah, I think that if folks would like to unmute themselves, they can go ahead and ask questions. And there's been a few questions in the chat already. And the first one that came in is there a time limit to when a will expires?
Good question. No. As an attorney, I would say always I would check in with your estate plan attorney and update it about every 10 years, just because there's something usually that changes in the laws about every 10 years, either state or federal. So you just want to do a check-in. But I've seen clients who have had wills from 1970, and that's what we're working with. They're not always the best documents, but a will does not expire. That's a good question.
Okay. And then if you have a savings account in only your name, it would be a personal asset. But what if you roll funds into it from a joint checking account? Would it then be a community property?
So, okay, so if we're looking at like the characterization of property between community and separate, so if you had your own separate one and then you put some joint property in there, yes, you could be commingling it. So when we look at kind of commingling and the characterization of property between separate and community, for estate planning purposes, we're looking at death. But if you're looking at it at the divorce perspective, anytime you mix community property and separate property, now basically you have to fight to prove what it is. So if it was originally your separate property and now you've been kind of putting in some joint, you have to somehow prove what your separate share is still. So anytime anyone's ever got like an inheritance or anything like that, I always say just keep that thing separate. Try and do it as much as you can, because all it takes is one bulldog divorce attorney to really make that a nightmare.
That's good advice. And folks, if you do want to just unmute and ask a question, it's great. It's helpful too if you raise your hand with that little icon thing at the bottom in the middle of the screen, and then you'll pop up to the top and we can see you a little easier. Carrie says, my mother has a will but no trust. I'm an only child. I have a signed beneficiary deed to her house and vehicle. Would probate still apply? I have been trying to get her to do a trust, but she is disagreeable to it.
I feel your pain, Carrie. It's happened. Yep. I had to convince my parents to do a trust. They only wanted to do a will. So it depends on that threshold, whether or not any other assets hit that $200,000 mark. So that's where I try and get people to create a list of all your assets. Write it down. Write down every bank account. You think about like retirement accounts. I have, which is really sad as an attorney, I have 3 retirement accounts. I have one because I briefly worked for the state. So I have a state of Arizona one. I've got the one with my current employer at Fidelity. And then I have one that's just been the biggest pain of butt and I haven't been able to transfer it to Fidelity. And that's on my to-do list. And so again, it's all these little things. So create the list, every single thing, because that's what you really got to find out to see if you're going to hit that $200,000 threshold. If she's going to be under that threshold with everything, then you should be okay. And I've totally seen, I've had clients who never created a trust. They didn't want it. They worked basically just off the beneficiary deeds, beneficiary designations, and you can do that. That is a totally valid, great estate plan. The only thing I caution is that keep the beneficiary designations updated. Okay, you're Carrie, you said you're her only child, so that should be you as the beneficiary. Should something happen to you, make sure she has a secondary on there, because otherwise it would go fall back into her estate and that could cause the probate. So always have a secondary beneficiary on there. If there's ever anyone else named and they pass away, something happens to them, make sure it gets updated. I will say, Carrie, just since you mentioned that, with a real estate now, if you have a beneficiary deed, you're just going to be kind of recording that deed, showing that it's now passing to you. So a fairly simple process. If real estate, say you didn't have a beneficiary deed, and the real estate fell under the $300,000 threshold, again, you don't have to go to probate. You just file a simple form with the court, and then that's how it transfers over to you. So, but again, you don't have to have a trust, but again, it's always my recommendation.
Thank you.
So does that answer this next question? What are the ramifications if your home doesn't have rights of survivorship?
Yep. So it depends how it's titled. So for example, my parents, I just sat down and helped them with our estate plan. And when I looked up their deed, because again, deeds are public record. So I was like, all right, mom and dad, let me look at your deed. Looked it up and it's just in my parents' name, Tony and Elizabeth. There was no rights or survivorship. So I told my parents, I'm like, you know what that means? Well, one, you're not taking advantage of community property laws, but that means, Dad, you could technically sell 50% of the house today. You could. Mom, you could go do the same. You don't have a 1/2 interest. You can't, there's not going to be that whole. So what that means is if my dad were to pass away, his 50% is going to pass through probate. That's not good. So they need to put the survivorship on there, or in this case, we're putting it into their trust, because if they have a survivorship on there, then whoever the survivor is, my mom or dad, they will get 100%. Or again, if you put it into a trust, you don't have to worry because the trust will always continue on with whoever the trustee is. So that's kind of the options there, depending on how, again, my number one homework assignment, look at how deeds are titled, because that's going to tell you a lot. Another thing in Arizona, again, because title agents just kind of do their thing when it comes to deeds, and no offense to anyone if you're a title agent, I'm sorry, but you'll see a lot joint tenancy with right of survivorship. That's the other common one. That's certainly fine. That's also a survivorship where the survivor will get the other bit, but you don't get income tax benefits. Let's take advantage of great community property laws. Not to get too into the weeds, but what I mean by that is, houses have shot up in value like crazy, right? So if I purchased my house and it was worth $100,000 when I purchased it, and let's say it's worth, easy math, because I'm an attorney and I don't like doing math, $200,000, there's $100,000 of gain there. And if I'm going to pass that to my kids and my kids decide to sell it, they're going to get taxed on $100,000 of capital gains. I don't want that for them. In community property, you get a step up in income tax basis on each death. So my husband and I, we have this house together, community property. So when I pass, our house gets a step up to its current value on the date of my death. Boom, eliminates all the capital gains. My husband lives another 10 more years. When he dies, the house gets another step up. So then when my kids decide, oh, we hated this house, we're going to sell it, there's no capital gains. And that just, again, helps push more of your assets to your beneficiaries.
So what's the average cost of setting up a trust? How much can we expect to pay?
Ooh, good question. Good question. So it typically, I want to talk about in terms of like the estate plan, because that's an attorney's going to want to do the full estate plan. They're going to want to do, because you have to have a pour of a will, right? So with the trust, they'll likely want to update powers of attorney, things like that. A full estate plan, and this is usually for, I would say for a couple, today is going to run between $3,000 and $5,000 for two people. Okay. With an individual, it's probably going to be less. I would say just one person, I would say $3,000 to $4,000. Honestly, to add an extra person isn't that much more work for the attorney. That's why the gap's not there. If anyone ever tries to do it under two, I would run. It's not going to be good work. And LegalZoom and Rocket Lawyer are not good options too. ChatGPT can't do it for you either. So it's definitely money well spent, because otherwise, again, if you're going through probate or you need an attorney's help later down the line, that's where the money's just going to be drawn from anyways, from the estate. So it's definitely worth the money up front. And most attorneys will do it on a flat fee too now.
And do you know, is there legal aid to help folks who couldn't foot that kind of bill if they wanted?
Yep, absolutely. So Southern Arizona Legal Aid is a wonderful resource. I've done pro bono work for them before, where I've drafted estate planning documents for clients. They're a fabulous resource.
Great, thank you. And then there's another question. I thought there was a separate mental health document relating to power of attorney. And yes, there is. There's the medical power of attorney, and then there's the mental health power of attorney, correct?
Yep, you could have a separate one, and sometimes attorneys put it into the healthcare one. They'll have the specific provisions in there. So every attorney does it slightly different, but there could be a separate, or it could all be combined into one.
Great. Oh, Elsa, did you have a question?
Yes, I just unmuted. I'll try to make it simple. Okay, I have a will, but no trust. My will is going to have a lawyer as the executor. Now it's going to have to something will have to be involved with probate, but that person who I've chosen in my will stays as the executor. The court doesn't appoint somebody else, or do they?
Nope. Correct, correct. So if you've named someone in your will, it's a good point. That's the person that you've chosen, and so that's the person who would be going to the court and saying, "Hey, I've been named in Elsa's document. I need to be appointed," and then the court will appoint them if they accept the position. Now, let's say the person is unable to serve, or they decline the position, then the court could appoint someone if there's a lack, if there's an absence there. But if you've got someone named and they're ready and willing to do so, then that's who the court's going to appoint.
You have a follow-up?
I'm still thinking about the trust question. You've made a good case for it.
I personally love trust. I kind of have an unhealthy obsession with trust. Again, I love them. But again, you don't have to have one. I truly believe there's a lot of benefits to them. But if you have a will and you have beneficiary designations on all of your assets, and you're keeping, account of them and making sure your beneficiaries are good and there, that is a perfectly acceptable estate plan as well. It will work.
And once the trust is set up for X number of dollars, is there an ongoing fee every year to maintain it? Anything like that? Or it's just the initial cost?
Nope, just the initial cost. It's kind of, yep, you see your attorney. It's, again, always good to check in with your attorney every few years just to make sure nothing changed in the law that would, need to be updated for your trust. But usually it's just that one time setting it up, and then it's just the hurdle of funding your assets, putting them into the trust. And what I mean by funding is just that retitling. Mm-hmm. So, recording a new deed to your house, which an attorney would do for you. They would put it into so that your house is in your trust. And then retitling bank accounts, calling up, if you have a life insurance policy, calling up the life insurance company to get that titled into the name of the trust. That's the legwork. I will give the heads up that financial institutions for checking accounts and savings accounts, they typically will change the account number if you retitle it. And if you have automatic payments set up, it's such a pain in the butt. Again, my 100% recommendation is always to have everything titled in the name of the trust, but that's why some people leave a checking account out. Again, what they'll do as kind of the backup, because they're just, we want to stay under those thresholds, is they'll put a payable on death beneficiary designation on the account, and they'll name their trust as the beneficiary. So then it just kind of like a pour over, just pours over into the trust, and it all goes from there. And that's an option too.
But IRAs cannot be in a trust. Yeah?
Correct. An IRA and a retirement account cannot. That's the only thing that's got to stay in your name. Yeah.
Okay. Thank you, Rachel.
You're
Thanks.
welcome.
Dina?
Yeah, thank you. And Rachel, you're very clear, and it's just really wonderful. You've done a great job, at least for me. I understand things better. So the question, I had the question about how much one costs, but the other question is, if you're getting ready to go see the lawyer, what should you have together before you go?
Good question. Oh my gosh, could all clients be like you? So that's going to cut down on time, right? Again, a lot of attorneys will do flat fees, which is great because you're going to pay this one fee. Some attorneys just say, you know what, let's do it by the hour. You might come out less, but you never know. You could come out more. So if you're more prepared, you're going to come out less. Have that list of assets. Have the total list of assets. Have your account numbers, where the account's located, the financial institution's name, everything on there. Cars, put the VIN number. You want to list because whoever's going to do the job of distributing your assets, they're going to need this information anyways. So it's a good list to have. Then there are 2 lists of people that you want to think about ahead of time. One is think of 3 people that you want to make financial decisions for you when you're unable to do so, okay? I always say a list of 3 because what if something happens to the first person? What if something happens to the second person? Hopefully it's not the Titanic and y'all didn't go on the same cruise ship, okay? And all 3 are gone, but hopefully 1, 2, or 3. You could name more than one person. I don't recommend it because more than one person means people could disagree. So usually one person's best. But if you truly love your kids and you think maybe your kids are going to go along, you could do 2. So 3 people that you would want to make financial decisions. This is the person that's probably going to be on your financial power of attorney. This is the person that would be the executor, your personal representative. This would be your trustee of your trust. That one list takes care of all 3 of those documents. Then you want a separate list, 3 people who are going to make medical decisions for you. It could be the same 3, it could be a different 3. Again, it's different set of skills, right? You may want someone who's more financially savvy on one. You may want someone who's going to be more empathetic, someone who has maybe more healthcare knowledge, or maybe someone who's just got the balls to be able to pull the plug if that really is your wishes, right? So come up with that list as well. And then the last thing is, how do you want things distributed? And that's kind of thinking of, who do you want? Is it friends, family members? Is it charities? And kind of have that in mind. And if you want any controls, again, are you okay with someone handing someone a check? Just a check with an amount of money on there, and they could do whatever they want, right? You hear of trust fund beneficiaries buying Ferraris, right? Do you want them to have that kind of access, or do you want to put more controls where they receive it in trust? So kind of think of those concepts as well. And if you do that, that's going to save so much time. You'll be the attorney's favorite client.
Thank you.
Great. And then Krista asked, some people say you should put your vehicle into your trust, and others say you shouldn't, because if someone gets into an accident in the vehicle, then they can sue the trust that the vehicle is in. Which items do you recommend not including, and why?
Good questions. Very common question. So it would depend on the vehicle. So again, because we're playing with those thresholds, for an average vehicle, right? If you've got your Toyota, your Honda, your even just the basic Tesla, right? You're not going to be getting close to that $200,000 threshold. You can keep it in your individual name. If you have a fancier vehicle, if we've got a Porsche, a BMW, a Ferrari, something that's going to push that threshold, if you have a classic car that's only going to appreciate in value, I would recommend putting it into a trust. Now, here's kind of the only hiccups with putting it into a trust. One, you got to go down to the MVD, and who likes to do that? 2 is you got to then switch over on the insurance side as well. The insured never really likes a trust as the insured, right? They always like individuals. So they might give you a little bit of grief, but it's totally doable. I have clients who do it all the time. But the argument that someone can sue you if it's in the name of your trust actually is not really a great argument if it's a revocable trust. Because with a revocable trust, you and the trust are one and the same person. So even if I have my car and I rear end somebody and I total their Ferrari and now they're coming after me and suing me, they could still access everything in my SAS family trust. Only if it's an irrevocable trust, then you would kind of open up that irrevocable trust to something. But just a revocable trust is you and the trust are one and the same. So that's kind of the still same access.
Great, thanks.
Okay, and one update, power of attorney form without going through an attorney.
You can. So I will say, so a healthcare power of attorney, you can go on the Arizona Secretary of State's website and they have their form there. As an attorney, that's where I took my form, right? We changed it into our format, but that's what we want because we want hospitals and doctors to recognize it and not question it. So you can totally get your healthcare power of attorney, fill it out. You got to get it notarized. So just go get it notarized, get a couple witnesses, but you can completely do that on your own without an attorney. You can update a financial power of attorney. There isn't really like a basic form out there, like, a standard, like a Secretary of State one for that one. And so again, I would not advise any of the virtual assistants out there who create those. So that I would recommend going to an attorney for. But if it's something as simple as just changing, the name of one of your agents or switching an order, that's a real quick switch for an attorney. That should not cost a lot for legal fees on that one.
And with the financial power of attorney, do you recommend, say, if that people also have sign their financial institutions forms? Because I know sometimes banks will have particular ones that
Mhm.
then it makes it easier rather than just using a generic POA.
Yes, yes. Thank you, David, for bringing that up. Absolutely. So I always would recommend if you go to an attorney and you spend big buku bucks on this beautiful estate plan, and then you go to a financial institution, 9 times out of 10, they're gonna just push that thing aside and say, "Well, here's our form. You need to fill this out." And you're like, "Well, why did I pay a dang attorney?" Every financial institution has their own form. Northern Trust has our own form. We will accept outside forms when the time comes, right? If X person is incapacitated and you're going on that date to get access, when push comes to shove, you can. But it's always good, again, if we're planning ahead of time, go to your financial institution, give them that beautiful form that your attorney already created, see if they will accept it. And if they push their own internal form, go ahead and fill out their internal form, because again, that's just one less question later down the line.
Great, thank you. Okay, we're going to try and tackle this one. When state reimbursement does not include long-term care, only includes routine health care through the end of life, Part B and maybe Part C, does this reimbursement only include premiums of Affordable Care Act healthcare or Medicaid premiums, or does the government reimbursement include both the cost of healthcare procedures and the premiums?
That is a great question. And honestly, I do not know the answer to that question. I apologize. I do not know the answer to that. Um, I'd have to I'd have to research it and get back to you. I don't want to steer you the wrong way. I'm not sure. My gut instinct is that it's going to include both, but again, I don't want to say that with any definity because I'm not sure on that one.
So someone says trust avoids probate time, fees, and procedures. Is that a fair statement?
Sorry, say that again, David.
Trust avoids probate time, fees, and procedures.
Yes.
That's a fair
Yes.
statement.
Fair
Okay.
statement. Yep. And
Okay.
avoids a properly funded trust. Yep. Avoids probate. You avoid that 6-month lapse of time. Your successor trustee can immediately step into your shoes and start taking care of assets, getting things distributed to beneficiaries. And then, you really don't have to deal with the courts and give out fees to the courts.
Here's a good question. We created a trust 10 years ago in Arizona. Recently, the lawyer we used was disbarred. Do we need to redo our
Oh,
trust?
well, it might be a really good trust. Depends what they were disbarred for. Because it was 10 years ago, I would recommend that it just get re-reviewed.
Mhm.
Take a look at it, you review it, see if you want anything changed. And then I would recommend going to an attorney, and even if it's just, a consultation and seeing if anything needs to be updated, I think that would be worth it.
Great. Julie, did you have a question?
I do. I was just thinking, Rachel, about the fact that when I think of my, the bulk of my wealth, I've never said that before. So, not our IRAs. So those can't fund a trust. So how do you, if you don't just have cash lying around, how do you fund a trust? Is it like the equity in your home, or can you talk
Yep.
a bit about that? And is there a minimum amount that you have to fund, kind of thing?
Nope. So you can fund a trust with, it's so funny actually, in most attorney documents, you'll see in there that, in just kind of basic contract law, you have to have consideration. You have to, two parties have to shake hands and, something has to be traded. So usually in most documents, they'll say for the consideration of $10, even though no one actually does anything with a $10 bill, a trust doesn't really function if there's no assets in it. So, there's no minimum value to it, but typically someone's home is usually that main player right there. And that's one thing the attorney will help with, is just immediately deeding that into the home. Beyond the home, it's bank accounts, like a checking or a savings account. If you have a brokerage or an investment account, those are your main things. Again, life insurance policies could be titled in the name of your trust. Anyone who owns a business, you're like an LLC. Usually the trust is the member of the LLC. Pretty much you can put anything into a trust besides a retirement account, and anything illegal. They do put that in the statute. No illegal stuff in there.
Great. Thank you.
All right. One last question for you. And basically, do you have any strategies that you can offer us about how we could talk to loved ones about estate planning?
Great question. So it's definitely a sensitive topic, right, to bring up. I've been an attorney for 8 years, and my parents just now did their estate plan. It's a conversation that's going to take a lot of time. When it comes to almost kind of the kind of managing up, right? If you're talking to your parents about estate planning, it's just you come up with like the fictitious story, right? Oh gosh, I just talked to my friend Sally, and oh my gosh, what a mess, and they had to go through probate, and oh, it was terrible. They said, Mom, Dad, do you guys have a plan right now? Or like, and here's the big thing, and I help families with this all the time. You don't have to talk about numbers, right? So many people, they don't want to let their beneficiaries, whether it's children or friends or charities, they don't want anyone to know what the numbers are, right? Because no one wants to create trust fund babies. No one wants to create someone who's going to be reliant upon future funds. You want them to grow up and be independent and self-sufficient. You can totally have those conversations without mentioning numbers. And I fully encourage that with all my clients, of just explain the structure. Why did you do something the way you did? I have so many generations I've seen blow up beautiful plans because they just didn't understand it. And so explaining to them, hey, I'm setting this up for you because I'm trying to protect you. I talked about my young kids, and I can't leave my minor children property, right? If you've got older children, you also want to protect older children or other just friends and families, right? And a big thing we think about in this world today is creditors. A creditor can be the owner of the Ferrari that I rear-ended on my way home from work. The most common creditor is an ex-spouse. So if you want money to stay in the family, and you don't want it to be, money to go to a future ex-daughter-in-law or future ex-son-in-law, you can create those controls, and you can protect that by giving your assets to your whoever your loved ones are in irrevocable trusts. That's an easy way of doing it, and again, it protects them. I had a client, their son, they love the in-laws, that they love their spouses, but one of the sons was a doctor. So he's got a lot of liability, right? God forbid he gets sued for malpractice. So they wanted to make sure that his portion of his inheritance would be set up in an irrevocable trust, so that if he ever got sued, no one's going to go after his inheritance. So there's, again, with the revocable trust, there's so many options for protections. If you're trying to make sure that a certain beneficiary, it's only for them. Or if you have a beneficiary who might be a spendthrift, and you don't want them to go to the casino with that money, right? You could set it up so that they're protected. Or a beneficiary who might have special needs. You don't want to give them money because that just disqualified them from Altex. That just disqualified them from Medicare. You can set it up so it goes into a special needs trust. And so it can still help them, and they can still get public benefits. So there's so many options. It's just really finding out what are your goals, and then the attorney will tell you exactly how to do it. But really just having those conversations of, let's set up a plan. And for me, it was, for my parents too, it was, what are your wishes? My brother and I get along great, but I want to know what you want done, and we'll make sure it happens. We'll make sure it happens. We'll figure it out. You can give us leeway or you don't have to, but let's just find out what your wishes are, because that's what we want to happen for you. And that can kind of help start the conversation.
Well, when you get tired of practicing law and doing estate planning, I think we would all like you to go teach law school, law students, to teach them how to communicate with their future clients because you're really good at this.
Thank
Thank
you.
you.
Thank
Thank you so much for all the information and how you presented it. And we're going to share the slides with everyone. And there'll be a recording of this session that will be available probably in about a week on our website. So it is a lot of information. I get it. I'm going to have to refer back to it to start. Did I hear that right? Do I understand that correctly? So it'll be up on our website in about a week. But Rachel, thank you so much for this time with us.
Thank you. Thank you for the opportunity.
Thanks, Rachel.
So we hope that you all will come back and join us again on June 18th at the same time. We're going to have Dr. Shaban Aaron and Dr. Laura Bradbury join us. They've done a lot of work and a lot of research around the importance of grief support that is culturally appropriate and takes into account who is seeking that support. And so we're going to learn from their experiences, hear what has worked for them, and what they've seen folks benefit from a very sociocultural lens in terms of grief support. So please go onto our website. You can register just like you did for this. And it's very simple. And then we'll send you the link and you can join us next month. And that one will be the third Thursday. We're just keeping you on your toes. Jennifer, did you want to say a few things?
Yes, thank you so much, Rachel. Um, as we close out for the evening, when you all exit Zoom, you will be asked to complete a survey. So if you could please answer those questions for us, it really helps us when we kind of evaluate the topics that we're presenting each month. And we do share some of that feedback with Rachel. So we just love you so much, Rachel. So 5 stars all around, everybody. So if you don't mind doing that. And then just before we close, I just want to remind everyone we're so grateful for your support in donating. These are just a couple of different ways that you can donate, but through our website. We also partner with some different shopping apps. So shopraise.com. It's really good for like buying gift cards for as the holidays come and birthdays or whatever. So that's a nice way to kind of buy for your loved ones and then also give back to Roots and Roads. Walmart Spark Good. If you're a Fry's shopper, you can link your shop card to donate a portion of your purchases to Roots and Roads. And then we also have a car vehicle donation program that you can learn about. That's on our website as well. And then as you think about taxes for next year or for this current year, donations to Roots and Roads does qualify for our Arizona state tax credit, and that's a dollar for dollar tax credit on your Arizona state taxes. So please consider us when tax season comes rolling around again. With that, I just want to say thank you everyone for joining us, and we hope you have a great evening.
Thanks, everybody.
Take
Hope to see
care,
you
everyone. Thanks so much.